How do you report sexual harassment to your company? Reporting sexual harassment in the workplace is a critical step that can make or break your potential legal claim. Under both Title VII of the Civil Rights Act and the Florida Civil Rights Act, failing to report harassment to your employer can severely limit or eliminate your ability to recover damages. Federal and state law recognize two main types of sexual harassment: quid pro quo harassment and hostile work environment harassment. Quid pro quo harassment occurs when a supervisor demands sexual favors in exchange for job benefits like hiring, promotions, or continued employment. Hostile work environment harassment involves unwelcome sexual conduct that is so severe or pervasive it creates an abusive workplace. This can include repeated sexual comments, unwanted touching, displaying explicit images, or persistent requests for dates after being told no. A single incident can qualify if severe enough, such as a sexual assault. Reporting to your employer is usually required before pursuing a legal claim due to landmark Supreme Court decisions. Under the legal framework established by these cases, an employer can avoid liability if they exercised reasonable care to prevent harassment and you unreasonably failed to use their reporting procedures. Begin by thoroughly reading your employer's harassment policy to understand who to report to, whether reports must be written, and any deadlines. If your employer lacks a written harassment policy, that fact may strengthen your legal case significantly. When reporting to HR, request a meeting specifically about harassment. Bring written documentation with dates and witnesses, and ask for written confirmation of your complaint. In Miami workplaces, many employers are subject to Miami-Dade County's Human Rights Ordinance, providing additional protection beyond state and federal law. If HR is unresponsive or part of the problem, you can report to higher management, the company's legal department, or file directly with the EEOC or FCHR. Anonymous reporting options vary by employer, and while they may trigger an investigation, they often provide less legal protection than formal complaints. The experienced employment law firm BT Law Group, PLLC, understands exactly how the reporting process works and can help protect your rights throughout. Their attorney team, led by Jason Berkowitz and Anisli Tarragona, brings valuable experience from representing both sides of employment disputes. This strategic perspective allows them to anticipate employer responses and effectively advocate for your case. Call BT Law Group, PLLC at 305-507-8506, located at 3050 Biscayne Boulevard, SDE 205, Miami, Florida 33137, to discuss your specific sexual harassment situation with an experienced lawyer today.